Fourth Amendment. The Fourth Amendment protects the person, property, and effects of individuals from unreasonable and unlawful searches and seizures. The Fourth Amendment has been incorporated to apply to states through the 14th Amendment. The remedy for a violation of the Fourth Amendment is suppression of the information received that is a fruit of the invalid search and seizure, known as the fruit of the poisonous tree. There are exceptions to when the remedy applies. State action. State action is when the state, or an agent of the state acts. Standing reasonable expectation of privacy. A person must have standing to bring a suppression claim. They must have a reasonable expectation of privacy, REP, in the item searched, or they must be subject to a seizure. A person can have a reasonable expectation in a private conversation. Persons do not have a reasonable expectation of privacy in open fields or for information in public view. The Supreme Court, SCOTUS, has found that person does have REP for a conversation in a public telephone booth if the booth is enclosed and the conversation could not otherwise be heard. In that case, the dispositive fact was that the police bugged the telephone booth, and the person was attempting to keep the conversation private. Plain view. An officer may search and seize evidence that is in plain view when they are lawfully present, the item is in plain view, and its illegality is readily apparent. Reasonable expectation of privacy. A person does not have a reasonable expectation of privacy in the home of another when they are not an overnight guest. A person does not have REP when they consent to a search. A person does have a reasonable expectation of privacy from searches to an otherwise private place when the search is effected through technology not available to the public and which enhances natural senses, Kylo. Use of a listening device. The Supreme Court precedent most closely on point, with respect to technology-assisted searches, is Kylo v. United States, which holds that when police use technology, which is not in general public use, to obtain information from the interior of a home which they would otherwise not be able to obtain unless they made a physical intrusion, then there is a search. Consent. Consent, for purposes of the Fourth Amendment, is governed by Schneckloth v. Bustamante. A court will evaluate the totality of the circumstances in determining whether consent was voluntary or not. However, consent is not a waiver. It need not be knowing or intelligent in order to be valid. Police are allowed to lie when they obtain consent, however, so the entry here will likely not be held to have been obtained through involuntary consent. Exigence. An officer may make an otherwise unlawful search when there is an emergency or a hot pursuit of a felon. Warrant requirement. A warrant must be supported by probable cause, a signed affidavit, state the place and items to be seized with particularity, and it must be approved by a neutral magistrate. Probable cause. Probable cause requires sufficient facts that would lead a reasonable officer to believe that the commission of a crime was probably happening, or has happened. The officer can use their own personal knowledge, lawfully obtained evidence, and the evidence of a reliable and verifiable informant to have grounds for probable cause. Facts alone may not be enough, but taken together, can lead to probable cause. Informants. SCOTUS has allowed such informants when the information is particular, and the officer verifies it through independent investigation. Fourth Amendment. Under the Fourth Amendment of the U.S. Constitution, which applies to states via the Due Process Clause of the 14th Amendment, all unreasonable searches and seizures of persons, properties, and papers are unlawful. Government conduct. The Fourth Amendment applies to conduct by the government. There must be conduct by a publicly paid police, or a person acting in the direction of the police. Reasonable expectation of privacy. In order to have standing to challenge a search or seizure, the person must have standing. Standing exists where the person has a reasonable expectation of privacy over the place or item to be searched or seized. A person has a reasonable expectation of privacy over his home. Warrant. A search and seizure are reasonable if it is based on a valid warrant. A warrant requires probable cause and particularity. Probable cause requires a fair probability that evidence of a crime will be found in the place or item to be searched. Particularity requires a description of the items that can be searched and seized. Probable cause may be based on information obtained from a reliable and credible source. Consent. A police officer may search an item or place with consent so long as the consent is voluntary and the person has apparent authority to consent. Exigent circumstances. There is also an exception to the warrant requirement where emergency circumstances require that the officer not wait for a warrant. Such circumstances exist where, say, a felon is fleeing or an officer is worried that defendant will destroy the evidence or instrumentality of the crime in the time it would take to obtain a warrant. Plain view. Evidence may be seized without a warrant if 1. The police officer was legitimately on the premises, 2. The item was contraband or evidence of a crime was in plain sight, and 3. The police officer had probable cause to believe that the item was evidence of a crime or contraband. Exclusionary rule. Evidence obtained in violation of a person's constitutional rights is inadmissible at trial. Additionally, evidence obtained from an illegal search and seizure will also be inadmissible as fruit of the illegal search and seizure. However, evidence that would be subject to the exclusionary rule may be admitted at trial if the prosecution can remove the taint of the evidence. The prosecution has the burden of showing by a preponderance of evidence that 1. The evidence would have been obtained through an independent source, 2. The evidence was inevitably discoverable, or 3. Intervening acts broke the causal chain between the illegal conduct and the evidence obtained. Fourth Amendment. Under the Fourth Amendment to the U.S. Constitution, which has been incorporated to the states via the Due Process Clause of the 14th Amendment, the government must not conduct unreasonable searches and seizures. Exclusionary rule. The exclusionary rule provides that the product of unreasonable searches and seizures in violation of the Fourth Amendment and coerced confessions in violation of the Fifth Amendment is to be excluded from any subsequent trial. Fruit of the poisonous tree. The fruit of the poisonous tree doctrine states that all products/evidence derived from police illegality are excluded/barred from introduction at trial. The fruit of the poisonous tree doctrine can be overcome if 1. There is an independent source for the evidence/contraband, 2. There was an intervening act of free will on the part of the defendant, or 3. It was inevitable that the police would have obtained that evidence. Harmless error rule. Even if there is a violation of the Fourth Amendment and the exclusionary rule/fruit of the poisonous tree doctrine, a conviction will not be overturned unless there is a reasonable probability that the jury's determination would have been different but for the introduction of that information. This is called the harmless error rule. Government conduct. Government conduct occurs when the publicly paid police or private police that are deputized with arresting power conduct an action. Standing. Standing is always present when 1. An individual owns a premises, 2. An individual is the possessor/leaser of the premises, or 3. The individual is an overnight guest at a premises. Warrant. A valid warrant has two specific requirements, 1. Particularity, and 2. Probable cause. Particularity requires the warrant to state with relative specificity the items to be recovered, the person to be arrested, or the areas to be searched. Probable cause. Probable cause is the reasonable belief that contraband will be found in the area to be searched, or reasonable belief that the individual to be arrested committed a crime. Informants. There are many circumstances where an informant's information may be used to establish probable cause. That being said, whether the informant may be trusted is based on the totality of the circumstances. This includes the informant's previous reliability, whether there is independent evidence to support the informant's testimony, and, most importantly, whether the informant's testimony can be corroborated. Good faith exception. Even if a warrant is invalid, a search/arrest may still be considered legitimate if the arresting/searching officer uses good faith in the execution of the warrant. That being said, there are a number of situations where the arresting/searching officer's good faith does not excuse an invalid warrant. 1. When the warrant is so lacking in particularity that no reasonable officer could believe in good faith that the warrant is valid. 2. When the warrant is so lacking in probable cause that no reasonable officer could believe in good faith that the warrant is valid. 3. When the magistrate judge who issued the warrant is biased, or 4. When the officer who obtained the warrant lied in the warrant application. Search incident to an arrest. Search incident to a valid arrest. When an officer validly arrests an individual, they are allowed to search the clothes/body of the person, as well as any area around the person within their wingspan. Any contraband/evidence of crime that is obtained as a result of the search conducted pursuant to a valid arrest is admissible, despite the absence of a proper warrant. Fifth Amendment and Miranda. Under the Fifth Amendment of the U.S. Constitution, which has been incorporated to the states via the Due Process Clause of the 14th Amendment, individuals are entitled to Miranda warnings prior to custodial interrogation. Miranda warnings include: 1. The defendant has the right to remain silent. 2. Anything the defendant states can be used against them in the court of law. 3. The defendant has a right to an attorney. And 4. If the defendant is indigent and can't afford an attorney, one will be supplied to her. The warnings need not be verbatim. As previously stated, the trigger for Miranda warnings is custodial interrogation. Custody means any situation in which an individual would not feel able to leave on their own volition. While this may be in a jailhouse, it can also occur in any other situations where police conduct does not leave a reasonable belief that the person can willfully leave. Interrogation occurs when the police can foresee that the line of questioning may elicit an incriminating response. Once there is custodial interrogation, the individual being questioned must be given the Miranda warnings. If not, the exclusionary rule and fruit of the poisonous tree doctrine may apply. Fourth Amendment. The Fourth Amendment of the U.S. Constitution incorporated to the states by the Due Process Clause of the 14th Amendment protects citizens from unreasonable search and seizure. The touchstone of a search and seizure is reasonability. This means that to conduct a search, the police officer or agent of the state must have a valid search warrant. Where there is no warrant, the search will be unreasonable unless one of the valid warrant exceptions exists. Exclusion rule, fruit of poisonous tree. Evidence seized in violation of the Fourth Amendment will be suppressed at trial. Further, under the fruit of the poisonous tree doctrine, all evidence gathered as a result of an unlawful search will be suppressed as well unless the government can show that the taint of the unconstitutional activity has been sufficiently attenuated. Attenuation. This is often shown where sufficient time has gone by between the illegality and the discovery of the evidence, or where there is an independent source for the evidence, or where it would have been inevitably discovered. State action. A search requires government action. Search. A search only occurs where the government physically intrudes on the person's person, property, or effects, or when the government intrudes on a person's reasonable expectation of privacy, REOP. Dog sniff. The Supreme Court recently held that bringing a drug-sniffing dog to the front porch of a home for the purpose of searching for drugs is a search under the Fourth Amendment. Although the front door is typically held open under implied consent doctrine, the use of a drug-sniffing dog exceeds this consent and is therefore a trespass. REOP. A search occurs where state actors intrude on one's reasonable expectation of privacy. A REOP exists where the person holds a subjective expectation of privacy, and the expectation is objectively reasonable. There is always an REOP in one's own home. Curtilage versus open fields. Curtilage is the area immediately around a home, and is intimately tied with the activities of the home. The court has found an REOP to exist there. Areas that are not curtilage are considered open fields, and there is no REOP in open fields. Sensory-enhancing technology. However, even in the open fields, the government action is a search if they use sensory-enhancing technology not available to the general public. Plain view. Plain view means that a warrant is not required when officers find evidence in plain view. For a search to fall within plain view, two elements must be met. 1. The officer must be lawfully in the place where he made the observation, and 2. The incriminating nature of the evidence must be readily apparent. Eavesdropping. Generally, there is no REOP in a conversation held in public. There is also no REOP for conversations held in private with another person. The theory is that when one speaks to another person, you assume the risk that that person may be a police informant. Police may not use electronic methods to eavesdrop on phone calls, but that is because there is an REOP that persons are not listening in on phone calls. Generally, there is no REOP in people overhearing conversations. The court has held that there was not a search where officers stuck their ear to a wall to eavesdrop on conversations overheard in the next apartment over. There would be a search, however, if the officers used sensory-enhancing technology or wiretapping to overhear these conversations. Exclusionary rule. Where evidence is obtained unlawfully under the Fourth, Fifth, or Sixth Amendments, that evidence is generally inadmissible against the accused. In Mapp v. Ohio, the Supreme Court held that the exclusionary rule is incorporated against the states. Moreover, under the fruit of the poisonous tree doctrine, all evidence obtained as a result of an invalid search or confession is also suppressed unless the government can prove I. An independent basis, 2. Inevitable discovery, or 3. An intervening act of free will. Fourth Amendment search and seizure. The Fourth Amendment provides that a person be free from unreasonable searches and seizure of their persons, homes, papers, or effects. State action. The Fourth Amendment is only triggered by state action. Thus, a state or federal police officer, or a private officer, that has been deputized by the city or state must be the actor in order to render the amendment applicable. Search/seizure. A seizure occurs under the Fourth Amendment, where the circumstances of the encounter are such that a reasonable person would not feel free to decline the encounter. A search under the Fourth Amendment only occurs where the D has a reasonable expectation of privacy in the area and thing searched, or where there is a government intrusion into a constitutionally protected area. Warrant requirement and good faith exception. A search or seizure is generally unreasonable unless the police have a warrant, or an exception to the warrant requirement applies. A warrant must be founded on I. Probable cause, 2. State with particularity the persons and places to be searched, and 3. Be executed in a valid manner. Where a warrant that is otherwise invalid is relied upon in good faith by the arresting officers, the search or seizure will be upheld as long as the warrant was not I. So lacking in probable cause or particularity as to render reliance unreasonable, 2. Obtained by fraud on the magistrate, or 3. The magistrate was impartial. Terry stop. An officer may engage in what is known as a temporary investigative detention under the Supreme Court's Terry framework, provided the officer has reasonable suspicion of criminality on the part of the D, which is based on articulable facts. Terry search. An officer that has reasonable suspicion of criminality based on articulable facts may also conduct a Terry search of the D, provided he has reasonable grounds for believing that the D is armed and dangerous. A Terry search must be limited to a pat-down of the outer clothing of the D, and must be limited to a search for weapons. In order to remove evidence that is not a weapon, the officer must have probable cause to believe the other evidence, example, drugs or a car stereo, is illegal. Plain view. The plain view doctrine applies where I. The police have a right to be where they are viewing, and 2. They see evidence, and it is immediately apparent the evidence is contraband. Fifth Amendment. The Fifth Amendment protects a person from being compelled to be a witness against his or herself. Due to the inherent risks of coercion in police custodial interrogations, the Supreme Court has held that a defendant must be given Miranda warnings before any confessions by the defendant are admissible against the defendant, unless used to impeach. Miranda warnings. Miranda is triggered where the D is I. In custody, and 2. Interrogated. For purposes of Miranda, custody is defined as a place where a reasonable person would not feel free to leave. Moreover, custody is assessed by looking to whether the situation involves the same inherently coercive pressures as station house questioning. Interrogation is defined as any line of questioning that a reasonable officer would find likely to elicit an incriminating response. Invoking Miranda. To invoke the right to remain silent, the D must clearly and unequivocally indicate his intent to invoke. Constitutional right to testify in defense. All defendants have a constitutional right to testify in their defense at a criminal trial. This right trumps any ethical obligation that Calvin, C. has to the court or the profession. Indeed, neither C nor the court can prohibit D from testifying in this situation. Right to proceed pro se. The right of a criminal defendant to be represented by counsel was held to require the right of self-representation in Faretta. Where a Faretta motion is timely made, and the court is satisfied that the defendant is competent enough to represent himself, the court is required to respect the dignity of the defendant and allow him to have the right to choose for himself and represent himself. Competence. The Supreme Court recently held that a defendant may be competent to stand trial, but nevertheless incompetent to represent himself. A court need not allow a defendant to represent himself if doing so would cause an undue delay in the case. The request must be timely. D would need to show he was immediately prepared to go to trial. Delay of any sort would be sufficient to permit the court to deny his FAR et motion. Fourth Amendment. The Fourth Amendment prohibits unreasonable searches and seizures by the state. Miranda. Miranda v. Arizona requires that warnings be given to an individual subject to custodial interrogation in order to protect the individual's right to be protected from self-incrimination. Exclusionary rule and fruit of the poisonous tree doctrine. The exclusionary rule requires that a court exclude evidence seized pursuant to an unlawful search or seizure. The fruit of the poisonous tree doctrine also provides that evidence that is obtained as a result of unlawful search must also be excluded, subject to certain exceptions. The exclusionary rule also requires the suppression of statements obtained in violation of Miranda, although the fruit of the poisonous tree doctrine does not apply to Miranda. Expectation of privacy. An individual has standing to challenge a search or seizure when they have a reasonable expectation of privacy in the place or property being searched. Search and seizure. A search is a violation of a reasonable expectation of property. A seizure is an instance in which a person does not feel free to leave based on governmental presence. Generally, for a search to be reasonable, there must be a warrant. A warrant is granted by a neutral judge and must be based on articulable facts shown in an affidavit and must be reasonable and particular in terms of scope and time. Routine checkpoint. Routine sobriety checkpoints are not considered seizures under the Fourth Amendment, so long as they are administered in a non-discretionary manner and do not detain individuals for an unreasonable period of time. Consent. In addition, a search or seizure is not unreasonable if an individual consents to the search. Valid consent must be knowingly and voluntarily given. Whether an individual validly consented is determined objectively, and the court considers whether a reasonable police officer would believe that the individual consented to the search or seizure. Plain view. The plain view doctrine provides that where a police officer has a right to be in the place that he is, any objects in plain view may be validly searched or seized if there is probable cause to believe that the objects are products or instrumentalities of a crime. Statement. A statement is obtained in violation of Miranda where an individual is in custody and an officer is interrogating the individual without first providing the appropriate Miranda warnings. Custody. An individual is in custody for the purposes of Miranda, where a reasonable person in his position would not feel free to leave and end the detention. However, the Supreme Court has specifically held that routine traffic stops did not constitute custody for the purposes of Miranda. In this case, therefore, the routine security checkpoint would not be considered custody for Miranda purposes. Interrogation. A police officer is considered to be interrogating an individual where his questions are reasonably likely to elicit incriminating statements. State action. The 5th and 14th Amendment of the U.S. Constitution protects people against state action. Exclusionary rule. Under the exclusionary rule, all evidence that is obtained in violation of the 4th, 5th, or 6th Amendments must be excluded from evidence. There are a few exceptions to the exclusionary rule, i.e. knock and announce, attenuation, and the causal chain, etc. Pretrial identification. Under the rules concerning lineups, police cannot use lineups that are impermissibly suggestive that have a substantial likelihood of resulting in misidentification.